Welcome to Employment Law This Week. I'm George Whipple. Last week, the New York State legislature passed a bill banning non-compete agreements. It's now waiting on Governor Hochul's signature. Epstein Becker Green's David Clark tells us more.
The new ban on non-competes, if enacted, would be a radical departure from existing New York State law regarding non-competes, which is based on the common law. Under existing law, non-competes, while disfavored, can be enforced if they're supported by sufficient consideration and they protect a legitimate business interest of the employer and they're reasonable in scope and duration. This proposed new ban, in contrast, would prohibit all non-competes on a prospective basis. That is, after the law goes into effect, any non-competes that are entered into on or after that date would be null and void. There are a couple of carve-outs that are specifically mentioned in the New York State proposed ban on non-competes. The first is provisions with respect to protection of trade secrets and confidential and proprietary information are still allowed under the bill. The second is customer non-solicitation provisions are still allowed, but only with respect to customers that the employee learned about during the employment with the employer. If the governor signs it, it becomes law 30 days later. So employers who have models or forms of non-compete agreements need to get those into compliance in short order.
Thanks, David. Non-compete bans like this are becoming increasingly common throughout the country. If the bill is enacted, New York will become the fifth state to ban virtually all non-competes, joining California, Oklahoma, North Dakota, and as of July 1st, Minnesota. In addition, at the beginning of this month, Iowa banned non-compete agreements for mental health professionals, and Maine expanded its ban to include licensed veterinarians in the state. We're seeing this trend on the federal level as well. The FTC released its proposed rule banning non-competes in January, and a vote is expected in April 2024. And on May 30th, NLRB General Counsel Abruzzo issued a memo stating that non-compete agreements violate the National Labor Relations Act. This is a clear indication that these agreements will be an enforcement priority for the agency. We'll watch this trend and keep you posted. Thanks again to David for joining us, and thank you very much for watching. We'll see you next time.